Moving on now to classification of trusts. Note, this is just a basic introduction. There are many other various different types of classification of trusts. The ones I've given you here are just a sample, and hopefully enough to allow you to understand it a little bit better. It'll include a lot of terminology, a lot of technical terms as well. Some of the types of trust that I will be explaining in this topic will be covered as a topic on their own in much more detail later on in the syllabus. Okay? In classifying trusts, the different types of trusts, the first distinction to make is whether the trust is a public trust or a private trust. A public trust is charitable in nature. So all charitable trusts are deemed to be public trusts. And charitable trust is a topic that we're going to be looking at in much greater detail later on. So that's all I'll say here. Private trusts are all trusts which are not charitable in nature. And private trusts in turn could be further subdivided into many different other categories, such as the express trusts, the implied trust, the resulting trust, constructive trusts, and so on. And we're going to look at each of these in a little bit more detail. So we start with the express trusts, which is a type of private trusts. It is a type of trust that has been intentionally created. And remember, the person who created the trust is called the settlor. An express trust can be created during the settlor's lifetime, in which case it is an inter-vivos trust, or it could be created in the settlor's will. Now, the person who has executed the will is called a testator. So if the trust was created inter-vivos, meaning during the settlor's lifetime, then this person is called the settlor. But if the trust was created in the settlor's will, then you refer to this person as a testator. Okay? The requirements and formalities for the creation of an express trust will be dealt with in a different chapter later. Just for now, quickly, there are very few formalities with regards to the creation of an express trust. So if we're talking about personality, meaning any property that's not land, all that's required by the settlor is to show that there was an intention to create a trust, and the trust property is certain and the beneficiaries have been named, have been specified, and that is enough to create an express trust. But if the trust property is land, then statute requires further formalities, namely it has to be written. There has to be some evidence in writing, but we'll come to that later. We move on to the implied trusts, which is a type of trusts that's the opposite of an expressly created trust. An implied trust is implied through a set of circumstances. I think I gave you a couple of examples in a previous lecture. So one example of an implied trust is where you have a co-ownership of land. So more than one person own the same piece of land. Then the Trust of Land and Appointment of Trustees Act 1996 implies that they hold that piece of land on an implied trust of land. Another example I think I gave you earlier was an implied trust where a person has died and their estate is held on an implied trust by the person they nominated in the will to look after to manage the estate, the executor. The executor will hold the deceased estate on implied trusts. This time it's implied by the Administration of Estates Act 1925. Okay. So the next two types of trusts that we're going to look at, the resulting and constructive trusts, they're also types of implied trusts because they're implied by circumstances. So let's move on to that. The resulting trust, there are two types, two categories of resulting trusts. There's the presumed resulting trust and there's the automatic resulting trust. I've given you a few examples here. It doesn't always, a presumed resulting trust doesn't always happen in these sort of categories. We're going to look at resulting trust in much more detail later, and you will see why there are always exceptions, okay? So in a presumed resulting trust, generally A buys property, so A has paid for the property, but A conveys the legal title of the property to B, or in the joint names of A and B. That creates a presumed resulting trust whereby B, in the first example, or A and B, will hold a property on trust for A. So let's say A buys property and conveys it to B. So B is now the sole legal owner of this house that A has paid for. But B now has the legal title. Now equity steps in to say, well, B holds it on presumed resulting trust for the benefit of A. Why? Because B did not contribute to the property, did not contribute any money to the property, so he must hold it on trust for whomever had actually paid for the property. Now, this is not always the case. Obviously, this presumed resulting trusts doesn't always apply. It depends on the circumstances, as we'll see later. Okay. So either A buys property, or A already owns the property and then A transfers the property to B, and B hadn't paid any money to A. So again, in this sort of situation, B will hold the legal title of the property, but hold it on trust, on presumed resulting trust for the benefit of A. So A becomes the beneficiary with the equitable interest, or another way to phrase it is the beneficial interests of the property. That's the presumed resulting trust. The automatic resulting trusts is imposed by, again, a set of circumstances, okay? And it's based on the maxim that equity abhors a vacuum. Equity does not like a vacuum. So it arises where there's a gap in the equitable title of property. The example I've given you here is, let's say property has been placed on trusts to benefit A for life, remainder to A's children absolutely, and then A died childless. Okay, A has now died, and A's died without any children. So under this trust, while A is still alive, A is only entitled to enjoy the property. So if it's, let's say, a house, A may be entitled to live in the house, or if the house is occupied, it's being rented out, then A is entitled to a percentage of the profits that's being generated by this property. What A is not entitled to do, because all A has is a life interest, A is not entitled to the capital. The capital goes to whoever is entitled to the remainder interest, and in this trust to A's children. But now A has died without any children, so there is a gap in the beneficial interest. And what happens here is equity steps in to impose on this property an automatic resulting trust, whereby the property, or rather the legal title, will go back to the settlor. Remember, the settlor is the person who set the trust up in the first place. Okay, so it goes back on automatic resulting trust to the settlor. If the settlor is still alive, obviously it goes back to the settlor. It doesn't matter if the settlor is dead, because it'll go to the settlor's estate, and it will pass to whomever is entitled under the estate. Yeah, so automatic resulting trusts. The next type of trust is the constructive trust. It's also a type of implied trust. It's implied again through a set of circumstances. Yeah, it's imposed by equity. And it's imposed where equity feels that this person had acquired the property through either fraud, for example, or there was some injustice to their ownership of this particular property, in which case equity will impose on them a constructive trust, i.e. equity makes them a constructive trustee, and they will hold this property, the legal title, and they won't be able to benefit from this property. Instead, they will hold it for whomever equity says is actually entitled to the property. So equity can step in when they feel that it's unjust, and then declare that the person holding the legal title is a constructive trustee. So impose on them a constructive trust and tell them that they now hold the property for the rightful owners. And the purpose, as I said, is to prevent fraud or to prevent unjust enrichment. The bare trusts is where the trustees hold property on trust for a sole beneficiary absolutely. This beneficiary is an adult, and they are entitled to bring the trust to an end. It means that there are no requirements that needs to be satisfied. This beneficiary is entitled to the trust property absolutely. So, for example, an example I could give you where there are certain requirements that must be met is, let's say, land is being held on trust for A for when he or she reaches the age of 30. So if A at this point in time is only 25 years old, then A is still a beneficiary, and this trust is not a bare trust because the trustees still control the trust property and hold it for A's benefit until A turns 30. Once A turns 30, then there are no other considerations, no other requirements that need to be satisfied. A becomes entitled to the trust property absolutely, and at this point, it becomes a bare trust. And A, the beneficiary, can tell the trustees, I want you to transfer the property to me, meaning transfer the legal title to them so that they become absolute owner, holding both legal and equitable title. That's how they bring their trust to an end. So an example I gave you, on trust for Jerry for life, remainder to Sally absolutely. So while Jerry is alive, Sally only has a remainder interest. Jerry is entitled to enjoy the whatever property is subject to this trust. But once Jerry has died, Sally gets the property absolutely. And at this point, trustees are still holding the legal title, but they are holding the legal title of the property on a bare trusts for Sally, because she's now absolutely entitled, and she can tell the trustees, I want you to transfer the legal title to me. Once they've done that, the trust comes to an end. Sally becomes absolute owner. A fixed trust is where each beneficiary is entitled to a specific share of the property. So a fixed trust, let's say it could be an express trust. So a settlor had expressly created a trust, like I've given you here the first example, for Rosie for life, remainder to Mark. So Rosie has a life interest, Mark has a remainder interest, so their interests are fixed by the settlor. Or the second example, let's say £1 million for Nigel, Sue, and Jerry in equal shares, each person entitled to exactly 1/3 of whatever the trust property composed of. So fixed interests. That's a fixed trust. A discretionary trust must have been expressly created by the settlor. So the settlor there must be a written trust instrument where he says, I want to leave, let's say, my house or £1 million or all my shares, for example, on discretionary trusts for, and then name the beneficiaries. So the example I've given you here on discretionary trusts for the grandchildren of Irene. Now, the beneficiaries here are Irene's grandchildren, but they have no, unlike in a fixed trust that we looked at earlier, they have no automatic right to any payment from the trusts because it's purely discretionary. Discretionary on the trustees' part, meaning the people who hold the legal title of this property. The trustees have no duty to pay any of the beneficiaries under a discretionary trust. They only have the duty to consider the beneficiaries, so they can choose to pay some of the beneficiaries, all of the beneficiaries, or none of the beneficiaries. It's entirely up to the trustees. So to recap, beneficiaries of a discretionary trust have no automatic right to payment, only the right to be considered by the trustees. The discretion whether or not to pay any or all of the money in the trusts lies purely in the trustees' discretion. Trust of land, I mentioned a little bit about it. It's governed by the Trust of Land and Appointment of Trustees Act 1996. It's basically any trust that includes land. It's known as a trust of land, and the provisions within the TLATA, Trust of Land and Appointment of Trustees Act 1996, governs all trust of land. A trust of land may be expressly created by a settlor, or it may come by implication where two or more people have bought land together. For example, trust of land will be covered at length in land law. So that's all I'll say about it. Now, unlawful trusts are trusts that contravenes either an act of parliament, meaning statute, or it contravenes common law, or the terms of the trust are contrary to public policy or general morality. Yeah. So when I say general, yeah, it's not contrary to general immorality, but trusts which are generally, where the terms are generally immoral, are considered unlawful. Such trusts are unenforceable. They're not effective. I've given you examples. Trusts which offend the rule against perpetuities and accumulations. I'll explain perpetuities later on. Trusts preventing people from getting married, for example. Trust intending to separate families. Capricious trust. Again, I'll give you examples of capricious trust later on in the Three Certainties lecture. Or trust which incites a crime, for example. Okay, that's all you need to know about unlawful trusts. I don't examine on unlawful trusts. And finally, voidable trusts. These are trusts which are prima facie valid, meaning on the face of it, they're valid, but they can be made void either by the court, so the court can declare such trust to be void, or they can be made void at the instance of the person who is entitled to do so. So there are some circumstances where a person can say, I don't agree with that trust. I want to declare that trust void, in which case it will be. We will come across examples of voidable trusts when we move on to the section on trustees later on. So the examples that I've given you for voidable trusts are Section 173 of the Law of Property Act 1925. Here it says that where land has been conveyed to someone, voluntarily conveyed or disposed of to someone with the intention of defrauding a purchaser, that would be voidable at the purchaser's instance. Okay, so the purchaser can say, I want to avoid that particular transaction. Yeah. And then the Insolvency Act 1986, the court may grant an order restoring the status quo ante if someone enters into a transaction at an undervalue to defeat creditor's claim. So let's say you have a person who owns a piece of land, and they are in debt. They know that the creditors will request an order of sale of their piece of land so that they could be paid. So what they do then is, let's say they transfer the land, or they sell the land to their spouse at an undervalue. And what a court can do here is they can restore the status quo ante, meaning they can undo the transaction. Yeah, they can undo the transaction so that the creditors can claim the land. Okay, so these are what we call the voidable type trust situation. And again, that's all you need to know about voidable trusts. You don't particularly need to remember Section 173 of the LPA, or Sections 423 and 425 of the Insolvency Act 1986, because again, I don't examine on voidable trusts under these two sections. And that's all for classification of trusts.